case briefs, and so much more. LSData's got what you're looking for.
In 2001, the Supreme Court heard the case of Circuit City Stores, Inc. v. Adams, which centered around the reach of the exemption clause in Section 1 of the Federal Arbitration Act, FAA. The issue at hand was whether certain employment contracts, specifically those involving transportation workers engaged in interstate commerce, were excluded from the FAA's mandatory arbitration agreements. The case began when Saint Clair Adams signed an employment application with Circuit City Stores, Inc., agreeing to settle any claims related to his employment through arbitration. After being hired as a sales counselor in Santa Rosa, California, Adams filed an employment discrimination lawsuit against the company in state court. Circuit City, in response, attempted to stop the lawsuit and force Adams into arbitration. The Ninth Circuit Court of Appeals initially ruled in favor of Adams, stating that the FAA exemption for transportation workers applied to all employment contracts. However, the Supreme Court ultimately overturned this decision, concluding that the statute excluded only contracts of employment for transportation workers, not other employment contracts, from the FAA's coverage. The Supreme Court's decision hinged on interpreting the phrase "engaged in commerce" to cover all employment contracts under the Commerce Power, while excluding retail-employed respondents like Adams. Despite challenges from the minority view, the court maintained this interpretation and sent the case back to the lower court for further proceedings. Although the court's reasoning was met with some opposition, it held that Congress likely intended the broad catch-all phrase to cover most workers, with specific exemptions for those in the transportation industry. The interpretation of these clauses in the FAA remains a subject of ongoing debate.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.